Welcome to this examination of the relationship between hard law and technical standardization in cybersecurity. We will explore the interplay between binding legislation and technical standards across 4 domains: information security, personal data protection, artificial intelligence, and digital forensics. The central thesis is that hard law establishes foundational obligations but lacks technical granularity. Technical standards bridge this gap, operationalizing legal mandates into actionable methodologies and give practical effect to legal imperatives. We begin with the introduction and theoretical framework, establishing the jurisprudential foundations. We then examine information security, covering the NIS2 Directive, Cyber Resilience Act, ISO 27001, and NIST frameworks. We proceed to personal data protection, focusing on the GDPR, the state-of-the-art, ISO 27701, and NIST privacy frameworks. Our artificial intelligence analysis covers the EU AI Act, ISO 42001, and the NIST AI RMF. We then examine digital forensics, addressing evidence admissibility, chain of custody, and the ISO 2703X/2704X series and NIST SP 800-86. Modern cybersecurity regulation is characterized by a dual-track normative framework. Hard law, directives, regulations, and statutes, dictates the what and why of compliance, establishing legal obligations and sanctions. Soft law, technical standards developed by ISO and NIST, dictates the how. Historically, scholars viewed this relationship with skepticism, concerned about democratic accountability. However, in cybersecurity, this dichotomy is obsolete. Legislation suffers from technological obsolescence. The legislative process is too slow for rapidly evolving technologies. Technical standards provide the agile, consensus-driven methodologies to interpret and fulfill statutory mandates. Hard law establishes obligations, but lacks technical granularity. Technical standards bridge this gap across 4 domains. The regulatory challenge is fourfold. First, technological obsolescence. Legislation cannot keep pace with digital evolution. Second, dynamic threats. Cybersecurity cannot be addressed through static prescriptions. Third, technical complexity. Legislators lack specialized expertise. Fourth, the need for agile frameworks. Standards provide the adaptation required.
The spectrum of normative instruments ranges from binding instruments, legislation, regulations, co-regulation, to non-binding instruments, standards and guidelines. Hard law is binding, justiciable, and enforceable through sanctions. Its authority derives from democratic legitimacy and establishes the what, but suffers from technological obsolescence. Soft law is non-binding, deriving authority from expertise and consensus, specifies the how, and is characterized by agility and technical precision. The symbiosis thesis holds that hard law and soft law are complementary.
In this area, legitimacy concerns are substantial. Private bodies like ISO exercise delegated public authority. Their processes are industry-dominated and lack democratic transparency. The presumption of conformity transforms voluntary standards into de facto compliance pathways, but mitigating factors exist. Legislative frameworks set normative parameters. Stakeholder participation enhances legitimacy. Judicial review scrutinizes standards adequacy. The state-of-the-art is a dynamic legal concept referring to prevailing technical knowledge. It is not fixed but evolves with progress. GDPR Article 32 requires controllers to consider it. The jurisprudence has emphasized that this implies that the technological level of measures must be considered. Standards are the primary evidence of the state-of-the-art. We now examine the first domain, information security. This section demonstrates how the hard law-soft law symbiosis operates in the foundational domain of cybersecurity governance. The InfoSec domain represents the bedrock of cybersecurity regulation. The legislative paradigm has shifted from prescriptive compliance to risk-based, outcome-oriented mandates, reflecting recognition that threats are dynamic and context-dependent. A comparative analysis of EU and US frameworks reveals both convergence and divergence. In the EU, the NIS2 directive establishes a comprehensive risk management framework. The Cyber Resilience Act imposes essential requirements on products with digital elements. In the US, the regulatory landscape is fragmented. HIPAA requires safeguards for electronic health information. GLBA mandates information security programs. All 50 states have breach notification laws. The FTC exercises authority under Section 5 to challenge unfair or deceptive security practices, while EU adopts a risk-based horizontal model with cross-sector application. US adopts a sectoral, enforcement-driven model. The standardization infrastructure centers on ISO EEC standards and NIST frameworks. ISO IEC 27001-2022 is the cornerstone of information security management, establishes requirements applicable to all organizations. It requires risk-proportionate controls, regular auditing, and certification. Annex A lists 93 controls across 4 themes. The Plan, Do, Check, Act methodology provides systematic lifecycle management. ISO IEC 27002-2022 provides a reference set of controls with implementation guidance, incorporating new controls for cloud computing and threat intelligence. NIST CSF 2.0, released in February 2024, is organized around 6 functions: govern, identify, protect, detect, respond, and recover. The new Govern function reflects enterprise-wide risk management. NIST SP 800-53 Rev 5 provides a comprehensive control catalog organized into 20 families.
The interplay operates through a dynamic feedback loop. NIS2 and the CRA do not dictate specific technologies, they mandate risk management pathways. ISO 2701 provides the methodology, while NIST SP 800-53 provides granular controls. This translation from obligation to methodology is the essence of Symbiosis. Under the CRA, harmonized standards confer a rebuttable presumption of conformity. This transforms voluntary standards into de facto compliance pathways. Organizations implementing relevant standards can confidently place products on the EU market. Adherence to standards is the primary evidentiary mechanism for demonstrating statutory duty of care.
We now examine the second domain, personal data protection, focusing on how the symbiosis operates in privacy regulation under the GDPR that establishes security as both a principle and an obligation. The GDPR's security obligations form a structured hierarchy. At the base are Article 5, Security as a Principle, and Article 24, Accountability. These establish foundational obligations. Data must be processed securely, and controllers must demonstrate compliance. The next level is Article 32, Security of Processing, specifying required measures, pseudonymization and encryption, ensuring ongoing confidentiality, integrity, availability, and resilience, timely restoration, and regular testing. At the apex is Article 25, Data Protection by Design and by Default, requiring privacy embedded into architecture from inception. Article 32 specifies risk assessment factors, state-of-the-art, costs, nature, scope, context, purposes, and risks to rights and freedoms. This risk-based approach allows controllers to calibrate measures to specific risks. Jurisprudence has profoundly shaped the interpretation of GDPR security obligations. In Schrems II, the court held that security is a prerequisite for lawful data transfers. The U.S. surveillance framework lacked essentially equivalent protections, partly because it did not ensure adequate security. In Latvia's Republika Saima, the court reinforced that proportionality of processing is linked to security adequacy. In C340/21, the Advocate General articulated a dual test for Article 32, technical relevance and qualitative effectiveness. This requires ongoing evaluation, not one-time compliance. The burden of proof is significant. A breach is not per se sufficient to conclude measures were inappropriate. Controllers retain discretion, subject to judicial review. However, failure to notify a breach could reveal either an absence of existing security measures or an inadequacy. The standardization infrastructure operationalizes GDPR requirements. ISO IEC 27701-2025 extends ISO 2701 to provide a privacy management system. It helps organizations manage privacy risks and supports GDPR compliance, organizes controls into role-based annexes, Annex A for controllers, Annex B for processors, and Annex D providing mapping to GDPR. Controls address consent management, data subject rights, data minimization, and privacy impact assessments. The NIST Privacy Framework is designed to be used with the Cybersecurity Framework. NIST's privacy risk assessment methodology provides practical guidance for identifying and mitigating privacy risks. The interplay operates across 5 dimensions. First, the state-of-the-art as explicit statutory factor. Article 32 embeds technical standards within legal assessment. ISO 27701 is the baseline for due diligence. Supervisory authorities regularly inquire about ISO 27001 implementation. Second, approved codes and certification. Adherence to approved mechanisms may be used as an element to demonstrate compliance. Third, the accountability principle. Controllers must demonstrate compliance. ISO 27001 and 27701 implementation creates systematic documentation, risk assessments, security measures, testing activities, and management oversight. Fourth, data protection by design. Article 25 requires privacy at inception. ISO 27001's lifecycle approach mirrors this, embedding controls into architecture rather than adding them as afterthoughts. Fifth, burden of proof shift. Failure to adopt standards does not automatically constitute breach, but shifts the burden heavily onto controllers to demonstrate that alternative measures are equally effective.
We now examine the third domain, artificial intelligence, focusing on the regulatory framework and its relationship to technical standards. The EU AI Act introduces a risk-based framework imposing stringent obligations on high-risk AI systems, including conformity assessments, risk management, and accuracy, robustness, and cybersecurity. The Act also requires fundamental rights impact assessments, addressing privacy, non-discrimination, and due process, and explicitly relies on European standardization, empowering the Commission to request harmonized standards. The AI Act establishes a graduated regulatory approach. High-risk AI systems face stringent requirements, requiring technical documentation, conformity assessment, post-market monitoring, and incident reporting. General-purpose AI systems face less stringent obligations, primarily transparency requirements. The Act distinguishes prohibited practices, unacceptable risk, high-risk systems, and limited-risk systems, and calibrates regulatory intensity to potential harm. The risk management system under Article 9 is comprehensive, requiring identification, estimation, adoption of measures, and effectiveness evaluation throughout the life cycle. This acknowledges that AI systems evolve and risks emerge over time. The Fundamental Rights Impact Assessment is a significant innovation. Providers must assess impacts on privacy, non-discrimination, due process, and other constitutionally protected interests, introducing a normative dimension beyond technical risk assessment. The Act establishes a presumption of conformity for compliance with harmonized standards, creating powerful incentives for standard adoption. The standardization includes existing standards and harmonized standards under development. ISO IEC 42001-2023 is the first international standard for AI management systems, specifies requirements for establishing, implementing, and maintaining an AI management system. It addresses transparency, explainability, and AI-specific risk management, requires AI policy, risk assessments, controls, and monitoring, is deliberately generic, applying to all organizations using AI. It does not prescribe specific techniques, but establishes a management framework. The NIST AI RMF 1.0 provides a voluntary framework organized around 4 functions: govern, map, measure, and manage, addresses civil liberties, safety, and security risks, encouraging organizations to treat AI risks alongside enterprise risks.
The interplay presents opportunities and challenges. Standards provide the technical vocabulary for the AI Act's novel concepts. Robustness, bias mitigation, and transparency supply methodological frameworks for understanding and implementing these abstract requirements. The gap period between entry into force and harmonized standard availability creates regulatory uncertainty. Providers must either await standardization, risking delay, or develop their own methodologies, accepting the risk these may later be found insufficient. This is particularly challenging for SMEs. AI-specific risks challenge traditional standardization. The stochastic nature of AI, data dependencies, and immature evaluation practices mean deterministic standards may prove inadequate. 4 key takeaways emerge from the AI analysis. First, standards provide the technical vocabulary for the AI Act's novel concepts. Without standards, these concepts would remain ambiguous. ISO and NIST provide methodological frameworks for implementation. Second, the gap period between entry into force and harmonized standard availability creates significant regulatory uncertainty. Providers must adopt proactive approaches while awaiting standardization. Third, AI-specific risks, emergence, stochasticity, and data dependency challenge traditional standardization. Standards for deterministic systems may prove inadequate for probabilistic AI, requiring ongoing adaptation. Fourth, practical implications. AI providers must adopt proactive compliance, investing in data governance, risk management, and documentation. They must also recognize that technical standards cannot resolve fundamental rights questions. These require democratic deliberation and human rights assessment. We now examine the 4th domain, digital forensics, focusing on the unique role of standards in determining evidence admissibility. Digital forensics occupies a unique intersection where technical methodology directly dictates legal outcomes. Unlike other domains, digital forensics lacks a comprehensive EU hard law framework. Obligations are dispersed across multiple instruments. This creates a de facto standardization-driven framework, where ISO IEC 2703X, 2704X series, and NIST SP 886 fill a regulatory vacuum. At the national level, rules of evidence and criminal procedure govern admissibility. Courts increasingly require demonstrable compliance with recognized standards as a condition of admissibility.
Forensics' legal landscape is fragmented. eIDAS provides for electronic signatures, seals, and timestamps, establishing presumption of integrity for sealed documents. National rules govern admissibility. Jurisprudence is equally significant. In the U.S., courts consider testing, peer review, error rates, and general acceptance. In United States v. Ganias, the court emphasized the necessity of rigorous chain of custody and data minimization to prevent Fourth Amendment violations. In R v. DeLugos, the English Court of Appeal emphasized rigorous methodologies and unbroken chain of custody. The ECTHR has held, under Article 6 ECHR, that evidence must be gathered with procedural safeguards guaranteeing integrity and protecting defense rights. In Vladimir Romanov and Dumitru, the court addressed digital evidence admissibility. Digital forensics is distinguished by a comprehensive suite of standards, providing procedural architecture for legal admissibility. ISO IEC 2737-2012 provides guidelines for identification, collection, acquisition, and preservation. It covers handling from initial identification through preservation, distinguishing physical and logical evidence, providing guidance on documentation, chain of custody, and hashing. ISO IEC 2741-2015 provides guidance on ensuring methods are fit for purpose, addressing validation, verification, and quality assurance. ISO IEC 2742-2015 provides guidance on analysis and interpretation, addressing continuity, validity, reproducibility, and repeatability, attributes courts require for admissibility. ISO IEC 2743-2014 provides guidelines for incident investigation processes, describing phases including planning, preparation, preservation, analysis, and reporting. ISO IEC 2044 addresses the interface between incident response and forensics. NIST SP 800-86 describes a four-step process: collection, examination, analysis, and reporting, and defines digital forensics as the process used to acquire, preserve, analyze, and report on evidence using scientific methods that are demonstrably reliable, accurate, and repeatable, such that it may be used in judicial proceedings.
Standards directly determine admissibility and probative value. Unlike other domains where standards serve compliance purposes, in forensics they function as gatekeepers of evidence integrity. Non-compliance can result in exclusion. The chain of custody must be unbroken. Seizure documented and witnessed, hashing provides cryptographic integrity verification, imaging creates a bit-for-bit copy. Analysis must be reproducible, documented, and peer-reviewable. A forensic report deviating from ISO 27037 or NIST SP 800-86 is highly vulnerable to exclusion. Deviations cast doubt on integrity. The burden shifts to demonstrate reliability. This creates powerful incentives for compliance. The human factor is critical. ISO 27041 requires qualified and competent staff. Laboratory accreditation is relevant to credibility. Three key takeaways emerge from the forensics analysis. First, digital forensics exhibits the most direct and consequential interplay between standards and legal outcomes. Standards determine evidence admissibility. This is a critical distinction from other domains. Second, the ISO IEC 2703X/2704X series and NIST SP 800-86 provide the procedural architecture for legal admissibility thresholds. They dictate exact procedures for evidence to withstand judicial scrutiny. Third, deviations expose evidence to exclusionary challenges. Forensic practitioners must maintain rigorous compliance. Legal professionals must understand both standards and their limitations. Standards are frameworks for expert judgment, not substitutes. We now examine the mechanisms through which voluntary standards acquire legal consequence. The most prominent mechanism is the presumption of conformity. Compliance with harmonized standards creates a rebuttable presumption that the entity has fulfilled essential legal requirements. Beyond formal presumption, standards serve as safe harbors for demonstrating due diligence. In areas where harmonized standards are not mandated, or where legislation refers to the state of the art, standards function as benchmarks for reasonableness. In tort law, adherence to recognized standards establishes a strong evidentiary presumption of reasonable conduct. The state of the art serves as a dynamic benchmark for compliance. It is determined by consensus across standards, practices, and literature. Standards function as evidence of the state of the art, though they do not definitively establish it. Presumption of conformity. Under the new legislative framework, and explicitly in the AI Act, NIS 2, and CRA, compliance with harmonized standards creates a rebuttable presumption. This shifts the burden of proof. Authorities must demonstrate non-compliance despite conformity. However, the presumption is rebuttable. If the standard is deficient or implementation inadequate, it does not apply. Providers remain ultimately responsible. The state of the art serves as a dynamic legal concept. It refers to prevailing technical knowledge at a given time. It is determined by consensus across standards, practices, and literature. Sword and shield. Standards function as both. As a sword, they establish breach by showing the organization fell below the standard. As a shield, they defend against liability by showing the organization met or exceeded it. CJEU emphasis on dynamic nature. The court has noted that what was state-of-the-art at design may be inadequate after years of operation.
This imposes an obligation to regularly review and update measures, and is particularly relevant in AI, where rapid evolution means today's state-of-the-art may be tomorrow's baseline. Compliance by design represents a significant regulatory evolution. By integrating standards into initial architecture, organizations embed legal compliance into the technical DNA of operations. This shifts focus from reactive compliance to proactive risk management. Built-in compliance reduces oversight risk. Moreover, retrofitting is more expensive than designing in. And organizational resilience. Systems designed with compliance adapt better to evolving requirements. GDPR Article 25 requires privacy by design. ISO 27701 provides the methodological framework. NIST 2 requires security in design. ISO 27001 provides the framework.
Despite strengths, the Symbiosis faces significant limits. First, voluntary nature. Non-compliance remains possible. Second, regulatory capture. Industry dominance may produce standards reflecting commercial convenience. Third, technological lag. Consensus processes are slow. Standards may be obsolete on publication. Fourth, generic scope. General standards may not address specific risks. Fifth, normative boundaries. Standards specify how, but cannot determine what objectives should be.
A comparative analysis reveals significant variations across domains. Information security exhibits high formalization with the CRA's presumption of conformity. Data protection exhibits medium formalization with the state-of-the-art explicit in Article 32. Standards evidence due diligence and operationalize privacy by design. Artificial intelligence is emerging with the AI Act's presumption, but a significant gap period. Standards provide technical vocabulary. Digital forensics exhibits low formalization with no comprehensive EU framework. Standards determine admissibility. 5 future directions are identifiable. First, greater integration. The AI Act's presumption represents the most formalized integration to date. Future legislation will likely embed similar mechanisms, increasing the legal weight of standards. Second, enhanced transparency and accountability. Reforms increasing civil society participation, oversight, and judicial review. Greater involvement of consumer representatives and fundamental rights experts. Third, agility, living standards. As technology evolves rapidly, the gap between change and standardization becomes critical. Living standards, continuously updated, may replace periodic revision models. Fourth, normative integration. Technical standards are necessary but not sufficient for fundamental rights. The AI Act's rights impact assessments reflect this. Future legislation will further integrate human rights assessment. Fifth, evolution of the state-of-the-art. As technologies and threats multiply, the state-of-the-art continuously moves. Organizations must remain vigilant. The future of digital trust relies on harmonious evolution of both hard law and soft law. The central thesis has been demonstrated across all 4 domains. The friction between hard law and soft law is illusory. A profound symbiosis exists, wherein standards give practical effect to legal imperatives, creating a coherent, if incomplete, juridical architecture. In information security, standards operationalize NIS2 and CRA risk management through ISO 27001 and NIST frameworks. In personal data protection, standards give content to GDPR's state-of-the-art and data protection by design through ISO 27701. In artificial intelligence, standards provide technical vocabulary for the AI Act's abstract requirements through ISO 42001 and NIST AI RMF. In digital forensics, standards provide procedural architecture for ensuring admissibility and reliability. Cross-cutting mechanisms, presumption of conformity, state-of-the-art, safe harbors, and compliance by design transform voluntary standards into de facto compliance pathways. The EU Cybersecurity Acquis represents a pragmatic response to regulatory challenges, coherent, yet with persistent legitimacy deficits and technological lags.
Thank you for your attention.